I know that, especially yesterday, there was some discussion about what actual rights everyone has, because I suspect for some of you, I want to ask, for those of you who don't really consider yourselves to be activists or who don't really consider yourselves to be involved, how many of you are worried about getting involved in part because you don't want to end up where your family members have ended up? Yeah, who doesn't? I mean, that's a normal concern, I would say. So I want to talk briefly about what you're allowed to do and what you're not allowed to do as far as the law is concerned. And we heard from Brother Jihad yesterday that the law is not the ultimate restriction on justice, and we know that from the histories of the civil rights movement, that some of the most powerful forms of dissent were, of course, unlawful, and that's always been true. That being said, it is important to know what you're allowed to do and what those risks are. So I want to briefly talk about what those are, because again, we expect you, when you go back to your communities, to keep organized, and that means you need to know as a citizen what you're allowed to say and what you're allowed to do and what risks come with that. So I'm going to briefly transition to talking about that. So as I mentioned yesterday, this country has a lot of protections about what, or at least officially, what you're allowed to say. You are allowed to speak your point of view, irrespective of that viewpoint, and generally irrespective of the content in any kind of public space. That includes public sidewalks, that includes public universities, that includes things like town halls, that includes forming an organization to petition your government to change its policies. Those rights, at least on their own, are extremely extensive. It's not true that, when I speak to younger folks, they think they're not allowed to say certain things per se. There's very few things in this country that you are categorically not allowed to say on their own. It sometimes doesn't seem like that because you see your family members getting in trouble. And you see what's going on in this society where it's clear that there's political repression. So you wonder, how can that be true? So let's talk about what those restrictions are. So there's only a few things that you can't say on its own, where if you say that thing just because you've said it, you get in trouble. There's a difference between you can say things, and as a result of something else, your comments can be used against you. You're still allowed to say certain things, but there's other things that you just can't say. So again, I mentioned incitement. That's where you incite a group of people to immediately be involved in some kind of illegal action. Like I tell this group, hey, everybody, let's go outside and burn a car or something like that. If I tell you guys those things, and those things are things that you could probably do, and it's reasonable for somebody to think, oh, if I were to tell those people to do that, then yeah, they might do that. Those kinds of things can get you in trouble. Likewise, true threats. Those are threats that you make where a reasonable person would think, oh, if somebody said that to me, I would feel like I'm in physical danger and something unlawful is going to happen to me. There's also, we talked about the example of lying, of defamation, where you can't make factually false statements about another person. You can make politically false opinion statements about somebody. Opinion statements about somebody that are totally unfair. You can say somebody's a racist. You can say somebody's a bad person. You can say somebody is a jerk. You can't say, I saw this person do this at this time and lie, especially if that causes trouble for that person. And a related factor is, you can't lie to an officer, a cop. You can't do that. You can be charged with a criminal offense for that. So those are examples of things where just because you've said those things, you can get in trouble. But you can imagine that leaves a lot of room. We're allowed to talk about things like revolution. We're allowed to talk about things like the country changing radically. We're allowed to say things in this country. There was an important case during the 60s in which a man said to an entire group of people in his protest against the draft to Vietnam, he said, oh, they better not give me a rifle because you know what? The first person I'm going to shoot if they give me a rifle is President Johnson. And then everyone in the crowd started laughing. Now they went after him and they said, no, that's a threat. And the Supreme Court said no. Because a reasonable person wouldn't have construed that as a threat. They would have construed that as a political statement. Now again, that doesn't mean that you always have good results, but the point is, there's an extremely broad expanse of things that you are allowed to say and that you shouldn't let people make you think you can't say them just out of fear. You're allowed to say those things on their own. Here's where it gets complicated. Just because you say something, it doesn't mean that it can't be used as evidence against you in a prosecution or in surveillance. So many of you have experienced how that ends up working in practice. Your family members made political statements that they were allowed to make. Statements about the wars in Iraq and Afghanistan, statements about Palestine, statements about armed resistance, statements about the legitimacy of the US government, statements about the legitimacy, the moral and ethical legitimacy of using violence in order to effect political changes. They were allowed to make those statements on their own, but you guys all saw what happened next. The informants came, they manipulated your family members, they engaged in these attempts to get your family members involved in criminal conspiracies, and then what happened? You went to court, you tried to say, hey, or if you're the person, your own family member probably said, or their lawyer said, hey, I was entrapped, I wasn't going to do this on my own. Some guy came into my life and gave me some money, or tried to convince me, or tried to manipulate me, and then what happened? The burden fell on the government to say, no, that guy was predisposed. And when it comes to the predisposition issue, that's where all those statements come in. So he was allowed to make those statements, but guess what? They can use those statements as evidence against you when you do this other thing, when you make this agreement to engage in illegal activity. Again, the example I used yesterday was, what if I go on Facebook and say, I really hate my wife? I'm allowed to say I really hate my wife. They're allowed to bring up the fact that I hate my wife if they want to prosecute me for my wife's murder. The other example of when speech is not really protected, even though you're officially allowed to say it, is when it becomes a question of who you say it to, or whom you say it with. Earlier last year, there was a panel that was organized by some professors at San Francisco State University about Palestine, and they invited Layla Khaled to speak on that panel. How many of you guys know who Layla Khaled is? Yeah, some people here know, but who definitely knows who Layla Khaled is the government and our opposition in the Zionist movement. They saw Layla Khaled, and Layla Khaled was, of course, famous during the 60s and 70s as a hijacker for the Popular Front for the Liberation of Palestine. Popular Front for the Liberation of Palestine is considered by the US government to be a foreign terrorist organization. The Supreme Court ruled that even if you're allowed to say stuff in general, if you say those things to somebody who is a member of a foreign terrorist organization, then that counts, or that could count, as giving the terrorist organization support. And that especially applies to things like expert advice. Now, in the case that this became the law, it was called Humanitarian Law Project v. Holder. In that case, a group of people were trying to give diplomatic and legal advice to a group called the Kurdistan Workers' Party. And the Kurdistan Workers' Party, according to the US government, is also a foreign terrorist organization. And the group said, hey, how can it possibly be material support for terrorism? We're telling these people how to sign peace agreements. We're telling these people how they can, comply with the Turkish law and get off the Turkish government's list of bad guys. And we're trying to help them conform their behavior to the law. And the government said, no, it doesn't matter. You are providing them expert advice. It doesn't matter that the expert advice has nothing to do with how to carry out a terrorist attack. It just matters that it's expert advice. And you can't give expert advice. Other examples of expert advice, things like translation. Not anyone can do translation. So how many of you guys have heard of the case of, I think he's on the wall, Tariq Mahana? Tariq Mahana was prosecuted partly for terrorism violations, partly because he translated documents that were produced by Al-Qaeda. And that translation was seen as speech coordinated with or produced for a foreign terrorist organization. And in the Layla Khaled case, it was quite absurd because when the San Francisco State University held this panel, the government didn't come after them, but the Zionists did. And the Zionists reached out to Zoom and YouTube and other corporations and said, hey, depending on what somebody might say on this panel to Layla Khaled, if it qualifies as expert advice, you're facilitating terrorism. And the people from these corporations said, you know what, yeah, that could be true, and we're not going to take the risk, so they canceled the panel. So that's an example of where you could have made the same exact speech on that panel, but because Layla Khaled was there, and Layla Khaled may have heard it, or Layla Khaled may have been coordinating the process of the speech, they can come after you. There's an important qualifier to that. You have to know that the person is a representative of a foreign terrorist organization. You also have to know that they are listed as a foreign terrorist organization. So, if Layla Khalid came onto the panel and said, actually my name is Layla Shmalad, and nobody knew who she was, you couldn't get in trouble for that. But again, you may still get in trouble.
Yeah, you don't have to necessarily know it's that organization is on that list. They can say, well, if you know that it engages in this activity.
Right. So
even though lots of other groups are not on the list, that's whatever. But so you got to be careful of that.
Ignorance of the law is not a defense. I said that to someone. They were like, "Thanks for telling me that." They didn't know.
Yeah, not knowing the law is not generally a defense. Well, the other half of the form is sometimes it doesn't have to be.
Sorry, clarify this again. It's very important. This is why Maria is in jail.
This is why what?
Ignorance of the law is not a defense.
Ignorance, not knowing what the law is generally not a defense. You're expected to know what's legal and what's not legal. The other example that Kathy mentioned was sometimes it's not to a foreign terrorist organization. Sometimes it's to what they call a terrorist conspiracy. So certain offenses are considered terrorist offenses just for doing things like hijacking, things like killing government officials. There's various government statutes that are listed as terrorism offenses. And if you say things that are in some way furthering this terrorist cause, then you can get in trouble as well. So for example, in some of our cases, people put things on Facebook or elsewhere where it said things like, I swear allegiance to Anwar al-Awlaki, or I swear allegiance to Osama bin Laden. At that point, again, you're technically allowed to say some of these things. Arguably, there's some gray area. But it's at that point, anything you do that's even vaguely in furtherance of your alliance to this terrorist conspiracy, which is how the government views jihadism and how it views ISIS and Al-Qaeda. Even the smallest thing, at that point, if you so much as, I'm trying to think of some of the real-world examples of how they use it. Even things like sharing something on Facebook, you're just doing a small thing that's seen as in furtherance of this conspiracy, that's where you get in trouble. So again, this is kind of a similar thing where it's a question of your affiliation with a group, or sometimes an officially designated group of people, or sometimes kind of an unofficial group of people that's involved in illegal activity. It's a question of you saying those things to people, or saying those things in coordination with people. The other example that a lot of people don't understand is stuff you say to an informant is stuff that can be used against you. That's the point. I had a call once from somebody who said, Amith, I think so-and-so is an informant. As a side note, I'm pretty sure it turned out not to be the case, but she said, I think so-and-so may be an informant. And so, what do we do? How do we get that person in trouble? And I said, what do you mean? What do you mean, how do you get that person in trouble? And she says, for being an informant. And I said, that's not illegal. They're allowed, that's the point. Of course they're allowed to do that. And if you invite an informant into your home, into your life, into your masjid, if you invite them in, and you make statements to them, and you say things to them, including things that are incriminating, things that could be used against you, that stuff can be used to prosecute you. It doesn't matter that you didn't know they were informant. It doesn't matter that you thought they were just your friend. That can be used against you. So those are the broad brush strokes and the broad limits of what the circumstances are and what you're allowed to say. Now, I understand that depending on what you're saying and who you're saying it to, that can make certain things very difficult. It's difficult to organize a panel that has Layla Khalid on it. It's difficult to say that you're loyal to Anwar al-Awlaki and then live a normal life. But that also leaves a lot of room for you guys to do other things that are unambiguously not criminal. Like going into your community and saying, I want to gather other people who will help me change the law. That is a First Amendment right. That is a right that you have. And again, obviously, anything you say could be used as evidence against you. But evidence of what? Saying things like, I want to do something violent, I want to kill people, I want to do that kind of thing. Those things can be used against you. There was never really a case, in most of these cases, where mere political speech and personal views about some of these issues on its own became evidence that somebody was predisposed to commit some kind of terrorist attack. Now again, people have their biases, people have their prejudices, but on its own, you're generally in a safe position to express your political view. As a general matter, that's something you should feel entitled to do. And if you're ever feeling nervous about doing that, there's an easier answer than listening to this presentation, which is just to call us, and we'll talk you through it. And we'll always be here to do that. I want to briefly segue to another related question, which is searches and surveillance. A lot of people say, oh, this is outrageous. I heard a news story about the Department of Homeland Security spying on our group. Or I heard a news story about the FBI spying on reporters. And you click the link and you say, what's the story? And it turns out it's the Department of Homeland Security going on Facebook and seeing what everybody says on Facebook. Or it's the FBI going to a protest and hearing what that person is saying, hearing what organizers are saying at a protest. What do you guys make of that? Do you think that's a violation of anyone's privacy? Legally, it's not. You know why? Because that's statements that you're making in public. You're in public. You don't have a right to privacy in public. That applies whether you're talking about a government agent or anyone else. If you say stuff on Facebook, yeah, you should expect that everyone can see it. I mean, assuming your permissions aren't set a certain way. And even then, you're giving that information to Facebook, so it's probably something that they could get very easily. If you go to a protest and say things at a protest, you should not be under the expectation that you're entitled to some kind of privacy. Everyone can hear what you're saying. That includes the federal government. There was an important case resulting from COINTELPRO, in which the U.S. Army, as its intelligence department, started coordinating with local police departments all over the country, because people all over the country, particularly black people all over the country, were rising up in a rebellion in the late 60s and early 70s. There's a mass rebellions taking place in urban areas, oftentimes coordinated by or involving the Black Panther Party. And the U.S. Army intelligence wanted to figure out who was involved, what they were doing, and how to stop them, and how to infiltrate their organizations and disrupt everything. And so they started gathering information. And they told the court, all this info, some groups of people sued them over it. They told the court, you know what, we didn't do anything wrong, we just got the information from newspaper articles. We just got the information from publicly available sources. Now what they didn't tell the court is that some of those publicly available sources included things like the visitation log for the grave of Martin Luther King, and they were taking the names down from that. It didn't include all sorts of other things that you wouldn't really expect the government to have any right or authority in a free country to be gathering. But the point is straightforward. If you say something in public, they can get that information just like anyone else can. The other extension of that is something called the third-party doctrine. The third-party doctrine says that if you are communicating, even privately, with somebody else, but in the process you expose some of that information to a third party, like, say, FedEx. You write a letter to somebody else, you're sending a letter to somebody, and stuff inside the letter is private, it's only for that other person. But you know what? FedEx needs to know where it's going. So if there's anything on the outside of the envelope, like this letter is to this person and from that person, they're allowed to look at that. And that means that, especially for things like mail carriers, they're allowed to at least look at the outside of those letters and document all of them. And you can imagine, some people say, oh, well, they can't see the letters themselves, they can't see who I'm talking to. But what if I'm writing letters to somebody that, that's somebody that I don't want people to find out that I'm communicating with? I mean, think about if I wrote a letter to somebody or placed a phone call. Same thing applies with phone calls, because you expose the phone number, at least to the phone company, and that means that's not something that's private. Some people think, and when the Bush administration started gathering phone call metadata, including data about who's calling who, they said, well, that's not a big deal because they're not necessarily listening to the call. But just think about what's being exposed when people can see who you're calling.
They were listening.
They were also listening.
It was illegal.
I'm going to get to that as well. But just from the third-party doctrine, think about something like if I called a suicide hotline, or if I was married but I called my ex-girlfriend every other night, or if I called an abortion clinic, or if I started placing calls to a group of people and they were only people involved in political activism and I was constantly calling them. It doesn't matter if they know what I was saying on those phone calls. They have my entire map. Now again, that used to be a more egregious abuse before Facebook and before everyone just started giving away all their personal information all the time. But it's still something that the government has been able to manipulate to the most extreme extent. And the most extreme example of that, I think, is the NSA spying programs that were exposed about a decade ago, where the US government said, all of those emails you're sending, text messages, all of that kind of stuff, at least some of it, if not all of it, we're allowed to gather it through this third-party doctrine because these messages aren't being sent in an encrypted fashion. And if you send an email to someone, hey, you're letting Google see the entire contents of your email. You guys know that, right? When you email somebody using Gmail and they have, Yahoo, Google and Yahoo can read your emails. How do you guys do that? Yeah. Okay. It's important to know that. Some people think that Google can't read your email. They can read your email. They may have a privacy policy that says, oh, well, we'll never read your email unless this, that, and the other thing. Usually there's something in there that says there's a law enforcement exception, which is a fancy way of saying if the government asks for that data, they'll probably give it to them. And you don't have any privacy right to say, oh, they're not supposed to do that, because guess what? You let Google read your email, you let Yahoo read your email, why not let the government read your email? And this is the importance of using end-to-end encrypted technology, which I'll talk about in a second. Now, there are still nonetheless some communications that really are private, like when you're speaking to somebody in private, in your home, when you're having conversations with somebody that's not public, that's not exposed to everyone, that's not exposed to the whole world, the actual contents of your mail, for example. And when it comes to circumstances like that, where they actually are conducting a search, they need to be able to justify it. And what counts as a search is, in the thing that you're trying to prevent from being searched, do you have a reasonable expectation of privacy? Now again, in the examples that I gave, the government has determined that you don't, because you're exposing that information to the public or to third parties anyway. But there's other information where, yeah, you might have a reasonable expectation of privacy. Sometimes it gets confusing, and the courts have kind of gone one way or another. But there's certain areas and certain things where, yeah, you have a reasonable expectation of privacy. What you're doing in your home when the doors are closed and the windows are shut. The contents of conversations you're having with people, provided again that you're not talking unwittingly to somebody who's from the government, in which case it's not really protected. In those cases, they usually need to do something. They can't just spy on you, and they can't just surveil you. But there's usually something they need to do. Traditionally, what they needed was a warrant. But in recent years, they've kind of watered down that requirement, and now there's a whole bunch of times where they said, oh, well, this is kind of an exception. You don't really need a warrant to do this, or you don't really need a warrant to do that. Some of the common exceptions that kind of affect all of us are police stops on the street. When a police officer stops you and says he wants to frisk you, he's allowed to do that. Generally, he only needs what's called reasonable suspicion. He doesn't need a warrant. He just needs to be able to kind of explain, oh, this is what made me think that person might have been about to commit a crime. And it doesn't really have to be particularly convincing. A classic example of this when the Supreme Court upheld this was an officer saw a guy walking back and forth in front of a bank. Walking back and forth in front of a bank, of course, is not illegal, but what you guys can probably guess why the cop was suspicious. That's what somebody would do if they're casing a bank before they want to rob it. So that was the example that gave us what's called reasonable suspicion. And some of you, especially those of you in New York who remember the stop and frisk years, know how much that's been abused, that they can find reasonable suspicion of very minimal violations, and they can use that to search your person. What they can't do, and I think this is an important distinction, especially for the 21st century, they can't search the contents of your phone when they stop you. If they ask, it's because they need consent. And they need consent because they're not allowed to do it on their own. So just say, I don't consent. It's an important thing to remember. Another exception is the vehicular exception. When you're on the road, they generally don't need a warrant or to stop you. They generally just need some kind of more minimal cause in order to pull over your car, usually traffic infractions and things like that. Once they've pulled your car over, once they have basically probable cause for a traffic violation, they can generally search your car, at least the parts that are visible to everyone, and to the extent that their suspicion of whatever it is extends. A lot of people don't realize that they can at least refuse to consent to the search of their car, and that in many cases they don't have reasonable suspicion to search your car, and the results of those searches get thrown out. But again, a lot of people don't invoke their rights. Another exception to the warrant requirement is what they call the public safety exception. So for example, you'll see, what are they called? The thing they use to stop DUIs. Like the breathalyzer test of these roadblocks that they set up where they stop the car and ask you to breathe into the breathe into the breathalyzer so that they can check. Now, as long as they do this in a randomized fashion, if they say, for example, stop every other car, or every fifth car, or something like that, as long as it's randomized, and the purpose is a public safety thing, they're not trying to necessarily prosecute you, they're claiming the real aim is to keep the road safe, and if you end up getting prosecuted as a result, that wasn't really the point, but that's the idea behind it. And that also applies, I think it's important to consider this public safety exception that they've kind of expanded to mean more and more things. It now also applies to immigration stops. So when they're trying to stop you for immigration papers, and they stop every other car, every fifth car, or something like that, and say, hey, show us proof that you're a resident of the United States, that you're a lawful resident, they're allowed to do that. There is a reduced right to privacy among people that are in some stage of the correctional system. Again, that includes a lot of family members, including family members who have come home. If you're still on probation, if you're on parole, they can usually show up at pretty much any time. It's subject to the agreements that they've made with the court, but in general, you don't have a constitutional right to challenge those searches. The last one that I want to emphasize is a very significant exception because it almost undoes most of the stuff we've talked about so far, and that's the national security exception. COINTELPRO, the program we talked about yesterday, was justified by the FBI by saying that the president's office, for the purpose of protecting the country, has its kind of own authority that doesn't really need to get the approval of the courts or of Congress in order to spy on people. And because we were spying on Martin Luther King and the college feminist group and all these other people because we were afraid that they were fronts for the Soviet Union and that they were going to wage a guerrilla war or some stupid thing, we can justify searching all of these people under the national security exception. Now, once the program was exposed, and several of these programs were exposed, the courts didn't agree. The courts said, no, not necessarily. There's limits to the presidential authority. Essentially, what ended up happening was Congress passed the law that some of you have unfortunately become familiar with, which is FISA. The FISA system basically set up a process by which, if the government wants to spy on somebody for national security reasons, they go to this secret court that's made up of justices from multiple appeals courts and I think the Chief Justice of the Supreme Court. And essentially, they don't have to show probable cause that you're committing a crime in order to spy on you. What they need to show is probable cause that you're an agent of a foreign power. And that includes a foreign terrorist organization or a terrorist conspiracy. And the evidence that they're allowed to show that court, in order to prove that you might be a foreign whatever, includes political statements or political speech you made. And this isn't something that just affects, I should emphasize, it doesn't just affect dissident groups and communities like ours. Even people from AIPAC, for example, tried to sue because it turned out the Bush administration was trying to figure out what kinds of intelligence the Israel lobby was actually sending back to Israel. And they were able to get FISA court approval to surveil several members of AIPAC for that reason. Now, as you guys know, when it comes to FISA stuff, especially after 9/11, even when it's ultimately used to prosecute you, you don't get a lot of that information for national security reasons. But the point I want to make is that when it comes to this exception, things that normally are done by the criminal courts, where you have to prove that somebody's doing something illegal, you at least have to show the judge that you have probable cause. It means essentially it's likely that somebody might be involved in some kind of criminal activity. You have to at least prove that before you're allowed to, for example, wiretap somebody's phone. With the FISA exception, they just have to prove that so-and-so is an agent of a foreign power. And I don't have time to go into it, but essentially, the NSA programs took advantage of that in order to essentially spy on large numbers of people and to get wiretaps on people in this community. I know this extends way before 9/11. So I mean, the Holy Land Foundation, Lena's dad. Yes. Yeah. Okay. Wait.
I mean, since to get time for Q&A, so that dinner is going to be 6.
So I'm just gonna finish up here by. I just want to mention. So Lena's dad and the Holy Land Foundation, all of these groups, as you may have known, they were being spied on all the way back to the 90s. And the reason they were able to do that was by using speech that Lena's dad is a foreign agent. And As a result, house gets bugged for years and years. So this is kind of the framework through which your speech rights are implicated by surveillance and by prosecution. And I wanted to give you guys an outline of what that is and how it works so you can protect yourself. The other thing I wanted to finish up with before I open it up for questions, and keep in mind, if you have a question, you can always reach out to me, and if I don't know the answer, I will ask somebody who does and get back to you. But first and foremost is, if you're ever traveling, if you're worried about your personal affiliations, your contacts with other people, keep in mind, you can spy on you. So there's nothing wrong with you keeping records of your own information, just in case, God forbid, you're in a position where you have to prove that you were here as opposed to there, that you were doing this as opposed to that. If you ever have to defend yourself, there's nothing wrong with you keeping information about yourself, provided you keep it in a way that's safe. I recommended once to a young woman who called me and said, I'm really afraid I said some stupid stuff on Facebook like 10 years ago. I'm worried it's been locked somewhere, and now I'm traveling to a Muslim country to study. And I'm afraid that somebody's going to try to say that I'm traveling there for illegal reasons or for reasons that could get me in trouble. And essentially, there's no way to preemptively protect somebody from being prosecuted. But the best way to do it was to keep track of everything you're doing. And I told her to do that by keeping a notebook. Keep tabs on every time you go somewhere. Every time you get on the train, keep the ticket. Keep records of yourself. So that if you're ever in that position that somebody's gathered information that can be used against you, you have information too that you can use to defend yourself. The second one is, keep in mind, it's not a joke. I mean, we don't have to wear wires anymore if we're informants because everyone is wearing a wire. Everyone is an informant. Look, 20 years ago, if you came to this conference, there would be no electronic record that you ever even came here. If somebody was like, yeah, I saw this guy at the conference, you'd be like, no. Now, there's a digital footprint, not just of you coming to this conference, but every time you stepped out to go to the bathroom, every time you went back to the hotel room, every time every little thing within enough distance for the cell phone tower to hit your phone, it's being logged somewhere. And that information, guess what? It's being shared with a third party. It's being shared with a phone company. So what does that mean? Yeah, they can get it. It was only very recently that the Supreme Court ruled that we'll make an exception to the third party doctrine for phone location data. And that was a huge exception. But the truth is it's still being gathered, and they can still probably get it. They would have to go through a few more steps. But it's there. And that means that information is being gathered. You don't have to worry about a person here wearing a wire because you're already wearing a wire. Keep that in mind. And that means, it's important to have good digital hygiene. This device does not need to be your life. You can limit the amount of information you share with other people, and it's important you do that. The other thing I want to just emphasize before I go is, download Signal. Signal is a great program. Signal is an end-to-end encrypted app that works like other applications are supposed to work or claim to work. It's an open source application that allows you to text messages to anyone. It's never been, at least there's no proof that anyone has ever hacked the encryption, and it's used very commonly. It's endorsed by Edward Snowden. So this is an app you can use. This is an app that I use with not just people that, clients and other people with sensitive communications that I want to protect, but even with friends, because it's useful. It has all the same features as like WhatsApp or anything like that. I'm going to stop there and open it up to questions. And again, if we don't get time to answer all the questions now, please feel free to ask me at any time, or email me, or text me on Signal. Sorry. The question was, do I recommend an app called Proton Mail? So the problem with Proton Mail is that email itself is not designed to be private. So if you use Proton Mail and you mail somebody else who's using Proton Mail, then those communications are encrypted end-to-end. The problem is if you use Proton Mail to email somebody that uses like Gmail, it's useless. So I would say in general, my personal belief is unless there's a communication that you intend to have made public anyway, like for me, a lot of the communications I make with other lawyers or with the courts or something like that, I expect some of that stuff might end up being public anyway, so I don't mind using email for that. But in general, when it comes to private communications, don't use email. Use Signal, use an encrypted application.
About a cell phone, I've heard of cases where people have been accused and charged with murder, and the only physical evidence was their phone being there, or them having their phone on them.
Yeah.
So that's illegal.
What is illegal?
like the fact that you can be charged because they said that you were in there.
So there's two different things. One thing is that cell phones give off different kinds of information. One is like the actual phone going to the cell phone tower. Right. So that's how any phone works. It doesn't matter if it's iPhone, Android, whatever.
Right.
And then separately, Google, because it's like its entire business model is based on exploiting your data. Google also has a bunch of other analytical services that separately log the data. So the rule is for the regular cell phones. For the regular cell phone data, they need a warrant. It's not enough to just ask the phone company to give that information, but they may be able to get it. The point is, it's not like in the old days where there wasn't information that they could get. Like the information is there, it's just a question of whether they can use it to prosecute you. And again, well, that's when it's a criminal prosecution. When it comes to a national security investigation, they'll ask the FISA court to turn over those records. And they'll probably get it because the standard is so low. So that's for the cell phone data.
Yeah, I was talking about location.
Right. That's for location.
So that information comes from the cell phone towers.
Yeah.
Oh wow.
Well, I mean, it's necessary for the cell phone to work, right? Like how you can't connect a cell phone to something unless the antenna knows where the phone is to send the beam. So, yeah.
Or I mean, who's giving that information up?
Well, the cell phone companies have it, and then the cops could just ask for it by subpoenaing it, which doesn't require a warrant. But now they have to get a warrant to get the location data. But the point is, it's there, and they can probably get it. So yeah, keep that in mind.
Would using like a VPN help for like location or stuff or no?
So a VPN is a virtual private network. This is what protects your internet traffic. So it says, when somebody tries to say, oh, look, this, maybe I run a website and I get a visitor to my website, and it'll say the number, the IP address for where the visitor is coming from. A VPN allows you to pay another company to basically make it look like you're coming from their website. The problem is, when people use the internet, a lot of times they don't realize that they're giving up all sorts of information about themselves, including, like, for example, if I use a VPN and I sign into my Gmail account, and my Gmail account is amithguptaccf@gmail.com, it doesn't matter what my IP address is. Everybody knows who that is, right? So I'd say VPNs help, assuming you're not giving the information away in other ways. So yeah. Yeah.
Thank you.
I was just wondering if you could expand a little bit more on what efforts are being done to chip away at material support laws, or just the context of that, because in many ways it feels like these kind of laws, or the effects of them are becoming even more negative on people. I was supposed to be on a panel with Leila Khalid at NYU, and Zoom canceled it, so it's not like the government came after us, but like you said, the Zionists came after us and they canceled the Zoom event. So we still had it outside of the NYU official Zoom account and just did it, on our own. But when they knew that that was the link that she was going to be at, they completely shut it down, even though it was through an academic institution. But it reminded me that I actually was on a panel with Leila Khalid a few years before through Skype, and nobody really knew about that kind of stuff or cared about it, and nobody heard about it. Nobody got it shut down. So it feels like these efforts to shut these things down are continuing to increase. And then back to more, I guess, to the material support issue. One thing I'm seeing is like grassroots movements or organizers kind of like pushing past that fear of material support to FTOs, because every other day I get a DM about sharing a Gaza Mutual Support fundraiser, and I've actually asked so many lawyers and legal organizations. My mistake, I haven't asked y'all, so I appreciate the opportunity to do it now, is, how do I deal with this? Because I do feel a sense of guilt and shame that I feel like I can't even share these fundraisers because I'm afraid of how it could be weaponized against me growing up seeing cases like the Holy Land 5, Foundation. And I don't even know what to tell the people who are sharing this with me, because when I've asked these other legal organizations, they say that they wouldn't even give any legal advice on it and to just ignore it, and it's dangerous. So we're not gonna we're not going to get through these problems by sweeping them under the rug and then waiting for somebody to get in trouble, and just the networks of people around these things, you know, how they can be impacted. So I know that wasn't such a coherent question, but I'm looking forward to your thoughts on that.
Well, we're doing stuff about material support, but that's at least what the lobbying piece is. So, I mean, the fact is material support laws are relatively new. They used to go through all sorts of hurdles to try to criminalize our activism and our humanitarian work as terrorism. And I mean, all throughout the early 90s and late 80s, what they were trying to do to go after the Popular Front for the Liberation of Palestine was to say, well, this is a communist group, and according to the Immigration and Nationality Act or something like that, there's a provision in there that says you're not allowed to immigrate to the United States if you're a communist. And they were trying to find all these weird immigration loopholes in order to go after people. But they weren't able, in general, to go after humanitarian work when it was actually just humanitarian work, because there used to be an expectation before you had to contribute towards a terrorist conspiracy. So in order to get in trouble for material support. So unless they could prove you were giving money towards the commission of something like hijacking an airplane or shooting a diplomat or something like that, something that they classified as a terrorist offense before, that's what they had to prove. And of course they could never prove that about people trying to donate to a hospital or something like that, because that's dumb. Then they changed the law after the Oklahoma City bombing and after the 1993 World Trade Center bombing. And what they said was there's this so-called fungibility exception to terrorist organizations, which is if you donate legitimate humanitarian aid to these organizations that do humanitarian aid as part of their normal political practice, how much ever money you donated to help them pay their humanitarian budget, they'll put that money back into the killing Jews budget or something like that. And it's a completely nonsense calculation that they made out of thin air. It's not. There's no evidence that that's how actual so-called terrorist organizations operate. But that's what they said, and the result of that is pretty much any aid that goes to an organization that has been labeled a foreign terrorist organization, where you know that the person you're giving aid to is part of that foreign terrorist organization, and where you know that they've been listed as a foreign terrorist organization, as long as you're giving the aid, even if it's for humanitarian purposes, you get in trouble. Now, of course, there are some important caveats there. They have to prove that you knew that they were designated, and they have to prove that you knew that the person you were giving it to was a representative. What happened in the Holy Land Foundation case in particular was outrageous because they never really even proved that. What they tried to say was that the Holy Land Foundation giving money to these zakat councils, which are charity councils, that was the aid, and the proof that they knew that these zakat councils were secretly controlled by Hamas basically came down to normal community relations between people in the Holy Land Foundation and people in the Palestinian community, some of whom had very publicly identified with Hamas before Hamas had been designated as a terrorist organization. So essentially, they were giving to these zakat councils because even the U.S. government was giving to them, so they figured what's wrong with that. But essentially, it came down to if they can try to claim that the aid is going to somebody that they think is an agent of a group like Hamas, and they think and they claim that you knew that that guy was from Hamas, and they can convince a jury of that, then you can get in trouble. And that's exactly what they did in the Holy Land Foundation case. Now, of course, as other people know, they did all sorts of, as Miko Pala talked about yesterday, they had all sorts of other ways to tip the scales in that case. But the point is, if they're, keep in mind, again, you ultimately are often the one who's expected to give your rights away. I think it's important, understanding the risks, you generally put that burden on them. And in that circumstance that you described, where you're giving humanitarian aid to a charity in Gaza, and there's no evidence of them being a front for any organization that's banned, and there's no evidence that you know that they're a front for an organization that's banned, and there's no evidence that you know that they're a front for an organization that you know is banned. When there's no evidence of that, and they have to prove all of those things, put them to the test. I mean, don't give it.
I think they would make something up, though.
They would make something up, but the point is they have to prove that to a jury. And the reality is jurors aren't as unreasonable in this country as is often described. But again, it's important to understand that those are the legal risks. Now, of course, you have to make the ultimate decision, but that's what I would say about the law.
Just to add something, they don't have to prove that you knew that was a designated organization. Because in like our case, Oh, sorry. They don't have to prove that you knew that that organization was necessarily designated, as long as like the informant, if the informant tells you, well, they do bombings or something, as long as you know, and it doesn't have to be a particular terrorist conspiracy, as long as you're supposedly aware, there's evidence that you're aware of the kind of activity they do, you don't even have to know that group is designated, if they're engaged in violence, which is kind of ridiculous because there's so many different groups that are not on the list that the U.S. supports that are engaged in violence. But anyway, that's the way it works. And when those laws were passed in the 90s, the material support laws, the Humanitarian Law Project sued in 1998. It was Humanitarian Law Project v. Reno, Janet Reno, if anybody remembers her. That case went through the courts, and they thought they would have won. Like, they would have won under the climate at that time, but it didn't get to the Supreme Court until 2010. Totally different climate post 9/11, and the Supreme Court upheld those laws and said, what Amith was saying, as long as you don't even have to know it's designated, but if you give any kind of support, even if you're trying to get them to stop using violence, that's material support to terrorism. If it's going to one of those groups and you know that they're engaged in something violent, that's all they need to prove. And so the ACLU actually had a bill in 2010 as part of something called the Justice Act to amend that to say that there had to be proof of an intent to support violence. And that didn't go anywhere, but that's where we got the idea to put that in our EGO bill, so that's one of the things we're trying to change. That's how we're trying to change it, to require evidence of an intent to support violence, not just to support your friend or whatever.
So I need guidance on how I can send money over.
Sorry, Saad was raising her hand.
I have my hand up for a while. Go ahead. No. So I need guidance on how and when I can send money, because now on the internet you get calls from Palestine, you get calls from England, or for a refugee camp in Lebanon that the organization is in London. There's so much, and I don't know who's that or what they are. Also, what about an individual? I get a lot of people from Gaza particularly. I don't know if they're Mossad impersonating Palestinians or whatever. I don't respond. It breaks my heart. I want to help in any way I can, but I cannot risk the issue. So we need guidance on the charity work.
Let me just address that and then we'll hear from Stuart. When it comes to giving money, one really useful tool to use is, again, I hate to call it a useful tool because it's really useful for them, but as a result of them being in power, it ends up being useful for us, which is the OFAC list. So there's a list on the Treasury Department's website that, especially if you're doing business overseas or anything like that, it's important to check that list for names and organizations that are on it, because it's illegal to give money to any of those organizations. If you download it, it's like 60,000 rows of people and organizations and names and things like that. Usually that's one place that I would check. And if there's a name on there that matches, yeah, you should be wary of sending that person money, and you could get in trouble. As far as anonymous people that you don't really know, I mean, I can imagine them trying to say that if you are giving money to people recklessly in a way where there's some other context that they can try to say that is connected to such and such a group, you're opening yourself up to risk. I think the way around that is to use organizations that are reputable and that you're less likely to face those kinds of problems with. Off the top of my head, I don't know which organizations that would be. The last time I donated to something in Gaza, I think it was I donated to ANERA, A-N-E-R-A, and there's another one called United Palestinian Appeal, and then of course UNRWA also is working.
People are doing without organizations.
Yeah.
That's the issue.
Yeah.
So, I mean, don't send money on the internet to people you don't know in general, as a rule. Ignore.
I mean, I just wanted to clear up or confirm, I guess, about the when it comes to money, the objective standard. So not that you know, but that you should have known, and so therefore you should have
known or should have known what?
That the organization that you were giving to could be linked to a FTO.
So the standard, unless Kathy, you can correct me, the standard is knowledge. Like you have to know that a group is a form of terrorism.
Specific knowledge. You don't have to know it's been designated. You have to know that it's doing some activity that is violent.
You don't have to know that it's designated, but you have to know that the person you're giving it to is from that designated organization.
Not that you should have known, but that you specifically know.
There's two separate things. There's one is, do you know that this such and such organization is designated?
Which you don't have to know.
Which from what I read in the 2339B prosecutions, they did have to prove that.
No, they don't have to prove that.
It's generally not the best defense to say I don't know something that's public anyway. So, but then there's a separate question of if you're giving money to somebody who they're claiming is part of this organization, they do have to prove that you knew that person was a person from that organization. Otherwise, some random person who's secretly a member of this organization could go around taking money from people, and people would get in trouble even if they had no idea who that person was affiliated with such and such organization. Okay. Yeah.
Like in the Yassin Araf and Mohammed Hussein case, the informant claimed to be from a group called JEM, which is on the designated terrorist list, right? And Yassin said he knew it was designated, but he didn't support it, and he never supported it, and he told the informant he didn't support it. He still got convicted because of the classified evidence and the judge telling the jury they had good reasons to target him. But there was no, and then Mohammed said he didn't know what that group was. He thought it was a Qawwali group, a music group. He thought it was a music group, but the informant never told him it was a designated group, so there was no evidence that he knew that at all, and they didn't have to prove that
but
because the informant told him that
the informant told him that they were from this group.
He said he's from that group, but he didn't tell him that it was a designated group. He never had to know that. He just told him that they do bombings in Kashmir.
Right, but that's what the government has to prove under the statute, that you knew that the guy was from this group, whatever that group is.
But you didn't have to know the group was designated.
Yeah, you didn't necessarily have to know that the group was illegal, but you had to know that the guy's from that group.
Yeah, he told him that.
Yeah.
Thank you. From what I understand, I just want to make a quick comment. From what I understand about Nardeen's comment about the legal organizations, like their hesitancy to give advice. So like the traditional rule is that you don't broadcast legal advice until you know that it's unless it's clear, unless you know that what it is, what you're talking about. And the problem here, especially with not money stuff, but the advocacy, like what constitutes coordinated advocacy under material support is a complete gap in the law, and it was intentionally left that way by the DOJ and by the Supreme Court in Holder versus Humanitarian Law Project, and anything that like is on the line of coordinated advocacy is typically not prosecuted because the Congress could step in at that point, and the DOJ is very happy to leave the line where it is within that chilling effect and keep people wondering and hesitant to engage.
So I would just say that I think that's part, and she's right that there's some uncertainty after you cross a certain line. So you should know what that line is before you're exposing yourself. So it doesn't, if you cross that line, you may not get in trouble, but you might get in trouble. And that line in these kinds of cases is you knowing that the person is a member of an organization that they banned or involved in a so-called terrorism-related crime.
Basically, what you're saying is that we're safer in numbers. That's the bottom line.
It's always true.
Also true.
Can we call in the back
I have a legal question. Thank you for all your help, by the way.
a little bit closer.
Sure, yeah, I forgot about that. So, when I was doing some legal research, I came across a doctrine called no prior restraint, and I saw some early Supreme Court precedents that basically stated that you're afforded your right to free speech so long as there's no prior restraint, i.e. that you can say whatever you want, and so long as you're allowed to say it, you had your free speech, but whatever the legal consequences come after that, then it doesn't matter, it doesn't impede on your First Amendment. Can you speak to that? Is that something that's still alive?
So prior restraint is the idea that before you've been given an opportunity to say something that you're not allowed to say, again, that was the first thing I discussed, is there's certain things that, it's not just them using it as evidence against you in a case. There's certain things you're just not allowed to say at all, like, let's go burn a car. I'm not allowed to, like, if I was actually saying to do that, that would be illegal. The idea is, what if somebody says, oh, you know what, I think if Amith comes to this conference, he's going to tell everybody to burn a car. So before it even comes to the conference, let's cancel the conference, and the FBI will come in and prevent the conference. That's prior restraint, because they're saying, okay, if he's given this opportunity to speak, he might say something illegal. That's not allowed. You can only prosecute somebody for making illegal comments after they make them. And the idea is that a just society doesn't try to preemptively predict when you're going to say things that you're not supposed to. Now, of course, as we know from this conference, they skate as close to that line as possible with these material support prosecutions. But that's what the doctrine of prior restraint says, basically.
Yeah, and that's kind of the perspective that I was curious about is, could they argue that we're not violating your First Amendment because you were allowed to say whatever you wanted to say, but we're going to still prosecute you for material support. And our prosecution of material support doesn't violate your First Amendment because there was no prior restraint.
Yeah, exactly. Because material support is itself illegal speech, or it's speech that is being used as evidence of this crime. So if they were to say, you're not allowed to talk at all because we think you might say something that could give Layla Khaled advice, then it would be a violation of prior restraint. But if you speak, give Layla Khaled this illegal advice and tell Layla Khaled how to, make peace with Turkey or whatever, then they can after that come in and prosecute you for that.
So doesn't this make the standard of what free speech is kind of extremely tenuous?
I think that's what most civil liberties people would say. The Supreme Court's response was, well, look, we're not banning the content of speech, we're just telling you who you're allowed to say it to. And so that's the difference. Yeah, it's stupid. Yeah.
Thank you.
Well, I think we're getting on toward the end of the supper time, and you've been a very stalwart audience. This is a long day, and I really appreciate all the questions you had afterwards. It shows you're really engaged. So we'll talk tomorrow, right?